Morning, Your Honor. Todd Prall on behalf of third-party plaintiffs.
Morning, Your Honor. Brooks on behalf of Bragg Gaming International and Bragg Gaming Group.
Morning, Your Honor. Jeff Hewell on behalf of Folk Other Games, Inc.
Get those names. Okay. Third-party defendants, motion to maintain AEO designation.
Thank you, Your Honor. Again, Brooks Westergard. Your Honor, third-party defendants, Bragg and Oryx, have moved to maintain AEO designation on various documents that were produced by plaintiffs. Those materials include non-public confidential materials, including employment agreements, documents concerning third-party defendants governing boards, and documents concerning Bragg's acquisition of Oryx and combination with former third-party defendant AA Acquisition, Inc. I think that kind of a step-by-step analysis here as to why these materials should be maintained as AEO. First is the language of the protective order, that has been entered in this case, which provides that highly confidential AEO designation should be reserved for extremely sensitive confidential information that are believed to be unknown to the opposing party or parties or any of the employees of a corporate party, the disclosure of which to another party or non-party would create a substantial risk of serious harm to its, his, or her competitive or financial position that could not be avoided by less restrictive means. So, Your Honor, we maintain that these materials fall squarely within that bucket and they should be maintained as such. And Your Honor, I think following on the language of the protective order, I think we need to talk about exactly why third-party plaintiffs are seeking to remove that designation. And it's important, Your Honor, because now we're talking about who exactly these materials will be provided to. It's important to recognize, Your Honor, as we laid out in our briefing, that there has already been a gag order issued in this case dealing with some of the prior conduct of David Mahon, who is the individual who third-party plaintiffs would like to be able to review these materials. In that gag order, this court found that Mr. Mahon engaged in a number of extrajudicial communications, including, quote, making false statements about this litigation and, quote, falsely portraying the court's rulings as favorable to third-party plaintiffs. Now, Your Honor, third-party plaintiffs want to characterize this gag order as moot and irrelevant to the termination on this motion. But, Your Honor, this court already held that because, quote, by making material false statements to regulators, threatening shareholders, and misleading investors on a public blog, even if this court were to issue jury instructions or change venue to mitigate the risk of an impartial jury, this would not cure Mahon's actions. And this is the person who we're dealing with respect to this AEO designation. And these designations, of course, Your Honor, are governed by the protective order, but they don't exist in a vacuum. And that is what we're trying to prohibit. Now, in their opposition, third-party plaintiffs, it will be impossible for us to prosecute this case without allowing Mr. Mahon to review these documents. But at the same time, Your Honor, they seem to suggest that some of these documents are outdated or not really relevant, but they're seeking to remove the AEO designation from all 14 of these documents and the entirety of this material. So, Your Honor, they're kind of talking out of both sides of their mouth. And Your Honor, it's ironic from our perspective that they put in their brief that, yes, they do have to prove each and every element of each and every claim they have brought, of which Your Honor knows there are many. But, Your Honor, they don't explain why they will be unable to prosecute their claims without Mr. Mahon's reviewing these documents. They say it will be impossible, but why? And they don't even allege what claims or causes of action or allegations in their very lengthy operative complaint they will be unable to prove or establish without Mr. Mahon reviewing these documents. Now, they've admitted time and again, and we've briefed this many times, that they admit that the third-party plaintiffs and the Bragg and Oryx entities are direct competitors, have been direct competitors. And, Your Honor, this is the exact type of material that, even if, as they put it, is outdated, that doesn't change the fact that this is non-public, confidential business information that if it fell into the wrong hands could cause a serious risk of competitive harm to the Bragg and Oryx parties. And that is exactly the standard that's laid out pursuant to the protective order. So, Your Honor, with that in mind, what the protective order says, what these materials entail, and who these materials are going to be given to, that is the basis of our motion, and that is the basis upon why we believe that these should maintain the AEO designation in this case. It is that risk of harm that weighs in favor of maintaining the designation, and they have not even made a real attempt to establish why they will be unable to prosecute. They have the material. We've had it for some time. We've engaged in a letter writing campaign on this issue, and finally, we're in front of Your Honor to put this to rest. And they cannot and have refused to explain exactly why they will be unable to prosecute their claims if the AEO designation is maintained. So, Your Honor, unless you have any questions, I will wait for my rebuttal.
All right, Mr. Prall?
Your Honor, I think we need to start at the beginning of this. First of all of the stuff that they argue in their motion are based on two things that just don't apply. Number one, they have not shown why these are highly confidential information that cannot be disclosed to the other party.
What's interesting to me is this is the third-party defendant's motion to maintain. It's not your motion to remove.
Well, that's because of the way the protective order was written, Your Honor.
Okay.
The protective order allows them to unilaterally designate stuff. We object to it, and when we object and send them a letter, they are required to file a motion to keep it on.
Okay.
So they still have the burden to show that they're unilateral. We didn't never agree that this was AEO. In fact, if you recall, Your Honor, when this motion came before us before, there wasn't an order in place for AEO, and we were prepared to argue that even if there was an AEO in place, this stuff is not AEO. And you decided not to address that issue. You said, let's get an order in place that allows them to designate AEO, which they had already done, and we'll address whether it's properly AEO at a later date, which is now. So that's the way this was set up. And let's look at what they did, Your Honor. They've only disclosed two types of documents that they've designated. It's either documents that are basically in the public record, or they have designated everything else they produced as AEO. They've not designated anything as just confidential. It's one or the other. They've not made any effort to say, is this stuff really stuff that we need AEO on, or is this stuff that just could be confidential? And the other point is, the only argument they're really making now is not that there's any harm on them if David Mahon has the materials. It's, David Mahon might disclose it to other people that would make harm. Guess what? There's no evidence, no record, nothing that David Mahon has ever disclosed any confidential information that was disclosed in this case to any third parties ever. The gag order has nothing to do with disclosing confidential information to anybody. The gag order only has to do with representations he made about these court's orders, which are public record. And if he made that's entirely separate issue than maintaining confidential documents. And their argument is somehow these records of employment agreements, most of which are expired, aren't part of their agreements anymore, and a transaction that closed and was made public back in 2018, documents relating to how that transaction occurred, and most of the documents are actually signed documents as part of that transaction. There are a few documents in a packet that clearly should have were confidential before the transaction closed, but after it closed, they're a public company, and a lot of that stuff became public anyway. And so to argue that these things somehow are about their current business, future business, any kind of strategies that would be bad to put in front of competitors, they don't tell us how that is so. And if you want to review the documents, Your Honor, I'm happy to let you look at them yourself. But the fact is, the first step is, are these really AEO? Are they really the type of documents that, as he said the standard, is extremely sensitive confidential information, the disclosure of which to another party or non-party can create a substantial risk of serious harm to his or her competitive or financial position that could not be avoided by less restrictive means? They have not met that burden with these documents. These are not documents that can't be disclosed to other parties in the case. We agree they're confidential, and we will maintain their confidentiality outside of the litigation, outside of the parties of the case, And Mr. Mahon will agree to do that. He's already, and he's never disclosed confidential information outside of this case that was designated by another party. He's never done that. There's no evidence that he ever has done that. The gag order has nothing to do with disclosure of confidential information. And so for them to say that if he has these documents or information of closed transactions, things that happened 4 or 5 years ago, that somehow he's going to get a competitive advantage of them based on their current financial condition or their current operations is just not accurate. And so they should not be able to just take every confidential document they have and say it's all AEO. That's what they've done. And not even make an effort to divide them out. And there are less restrictive means if they really felt like they needed to do so. Example, there are employment agreements in here. If they wanted to redact the amount of money that was being paid to those employees, that's fine. That's a restrictive mean that we'd be okay with. But the point is that they haven't met the original burden to show that they should have AEO to begin with. And therefore, there shouldn't be an AEO designation. The second, and so that's really where we stop the analysis. We're agreeing that it should be confidential. We're agreeing that we're not going to disclose it outside this litigation. If my client breaches that, they have remedies in the order that they can pursue. But he has no intention of doing that, and we're not going to do that. But he should be able to review these documents. And so it really should stop there. There's no balancing act to go about whether he needs it for trial or whether if they're really not even highly sensitive enough that they deal with current operations or current financial condition of the company or anything that relates to their business right now. They don't. They relate to past transactions. And they may try to argue, well, there's stuff in there that maybe talks about stuff they're planning on doing in the future. Frankly, they're a public company. Most of that stuff is disclosed when they did this transaction. All those things are disclosed about what they're doing in the future and all those other things to the extent they're even there at all. So for them to argue that these are highly sensitive, there's no Coca-Cola secret formula in there. There's no documents about any highly sensitive software program that they have rights to. There's none of that at all. So that's where it should stop. Secondly, even if you go to the next analysis, Mr. Mahon is the person in this case. He's the primary principal of the third-party plaintiffs. If he can't at least look at the documents that are the core transaction that we claim was improperly done, the purchase of Oryx by Bragg, then we're not going to be able to prepare for our case adequately. We don't have the information as attorneys that he has about the facts and the circumstance of this case. There are things that we would not see that he would see if he could see all of those documents. And it's not fair or right for them to keep him from looking at these documents, especially when they really aren't highly sensitive. They're just not. They're not those type of documents. And so there's no hurt on them and risk. The protective order protects them from being disclosed to the world or anyone else. There's no basis for them. There's no basis that these documents are going to create any problem. Just because they're competitors doesn't mean that they can keep everything from each other. It has to be stuff that's sensitive enough and relates to their current business operations that might create a business advantage. These don't do that. So, and again, Your Honor, you did not make this decision before. They unilaterally designated these. We objected them being designated from the beginning. And they still need to at least meet the initial burden of why they think these are sensitive in that way. Last of all, the last point, we made this point in our brief, Your Honor, that really this appears to be, what they're trying to say really is that because there's animosity between these parties, they should just be able to keep Mr. Mahon from looking at any of these. And they should be able to punish him for something that's not related to this issue at all. And if there was an issue with the gag order, that's been handled. That was a different issue, has nothing to do with confidential information being leaked by any of the parties.
When I was reviewing this, what about allowing you as counsel to meet with your client and review them in person, okay, without providing them to him? In other words, without providing copies, without allowing pictures to be taken, taken and things like that. I mean, that would permit you to review the items with your client, and he would be allowed to see them in that context, but they wouldn't be taken or whatever.
I mean, Your Honor, if these documents were really AEO, were really stuff that were important to this litigation, that were really something that if he saw them gives him some kind of advantage over them, if they really were about stuff about their current operations or stuff about like some secret
My understanding
stuff.
is your whole point is that you need to be able to review these things with your client, right?
That's correct. And if you're saying that I can be with him and let him review everything and just not give him copies, is that what you're saying? And let him look at every single document, but not let them out of my office or into him personally.
Not take pictures of them, not make copies of them.
I still think, Your Honor, that puts an undue burden on us to force us to spend the amount of time being with him for all that. I don't think that's right or fair, especially when there's no reason to do it. The point is, they don't need any more protection than just maintaining the confidentiality of the documents from the outside world. There's nothing in there that my client could use in any kind of way to make a competitive advantage towards me. And these protective orders of confidentiality are fine for most documents. It's only highly, highly sensitive documents. And frankly, most of the cases that are dealing with this are cases where you have trade secrets and patents and all these things and those types of software litigation cases where all the parties kind of agree, yeah, this is kind of highly sensitive. We don't have that here. We don't have those types of documents. This is a typical transaction that we think these documents will maintain their confidentiality from the world. We just don't see any reason why the parties can't see them. And frankly, we don't see anything that they've given us that shows that Mr. Mahon even has a history of ever disclosing.
And you deem them to be relevant to your third party?
Yes, because all of these documents center around the transaction of Bragg's acquisition of Oryx, which has always been the central point of this case and who was involved in the acquisition and how they made it happen. And it was not a very straightforward transaction, so it was difficult to figure out what happened without all these documents.
All right. Thank you. Last word?
Thanks, Ron. I'll be brief. So what I heard from opposing counsel was, that first of all, faulting the Bragg parties for unilaterally designating these as AEO, as opposing counsel concedes. That's no fault of ours. That's exactly how the protective order is structured. So that was the option. Secondly, the language of the protective order itself doesn't talk about actual concrete harm that has occurred by disclosure of these documents. It talks about risk, and that's what I was talking about earlier, Your Honor. This doesn't exist in a vacuum. We believe that Mr. Mahon's previous conduct in this litigation, while it may not be that he has that we know he's disclosed any confidential information, the fact remains is that he's contacted shareholders, made public blog posts, and regulators to try to broker a settlement, and that was Exhibit C, I believe, to the motion for the issuance of the gag order in the first place. That has been, from our perspective, the point of this litigation in the first place was trying to coerce a settlement. And then, excuse me, finally, Your Honor, I think this applies to both who the documents and materials are going to be disclosed to and the risk of disclosure. Prior practice informs future conduct, right? So the fact that these materials are, in their words, outdated does not change the fact that disclosure of the same could give a competitive advantage to third-party plaintiffs, okay? The same thing applies to who these are disclosed to. I've gone over that, Your Honor. But again, past practice informs future conduct. We believe there is a substantial risk of disclosure. They admit that these are confidential, and we still maintain the disclosure of which would pose serious risk from a business perspective to the Bragg parties in this case. Unless Your Honor has any further questions, that is all I have for you.
All right, thank you. I'm going to deny the motion to maintain AEO designation, but I'll require that the items, Mr. Mahon can review them, not necessarily have to be with you, but review them at your office. All right, Mr. Prall?
So you're just saying that we can't send him electronic versions; they have to be maintained at our office.
Right, and he can come in and review them, and then you can set up an appointment with him to confer about them or whatever. All right, but Copies aren't to be provided, right? But you can have the file there at your office. You can make arrangements to come in and review them, to prepare for consultation with you regarding them, okay? So
So you're kind
I'm
of
denying the motion.
You're kind of creating a protection to keep them from going outside of our office. I mean, honestly, it doesn't matter to me how you say it, but you're just saying there's an extra protection for them that's not just giving them to our client. Maintain their confidentiality, but he can see them all.
Right. Okay? So I need a proposed order. If you can't agree upon one, you can submit competing orders.
Okay. I will attempt to do a proposed order. I have a feeling we'll probably be able to agree on language on this one, but hopefully.
All right.
And I would represent to you, Your Honor, the order that you presented, the order that was in place, protective order, we finally decided to agree to that one, and that's kind of why it was just ensured that we didn't.
Okay. All right. Thank you.
Thank you, Your Honor.
And if you prepare a proposed order, make sure to run it by opposing
Run it
counsel.
by Mr.
I'm sorry, Your Honor. One more point of clarification. The party plaintiffs did request fees in their opposition. I'm assuming you're denying that request.
Yeah, I'm not going to grant any fees at this point. Okay, thanks.
Thank you.